and good luck to the participants. Thank you, Patrick.
Thank you so much, Alexandre. So as you mentioned, I think it's really a truly participative dialogue as we had conceived, and now we'll really dive into some of the conversations and the questions that we have from the participants. Just some housekeeping in terms of if you can mute yourself while other speakers are talking, and if you want to take the floor, please raise your hand or feel free to put the question in the chat, and we would call the participant out. We're trying a little bit of a new format versus a webinar. We've kind of really opened it up for everyone instead of limiting to panelists and speakers to facilitate that interaction. But for purposes of keeping it manageable, I think raising the hand would be quite helpful. So in terms of framing the conversation, we thought in this first part, we'll try to discuss digitalization from the angle of substantive justice, so around fair decisions, around procedural justice, around fair processes, and around open justice vis-a-vis issues of transparency. And this is going to be the overall chapeau for this first conversation. And before we go into that, I would like to invite our three panelists who are course lecturers to also share what they are talking in the course, which offers an entry point for us to kickstart the conversation. So I'll first invite Grace Mutungu, who's an advocate at the High Court of Kenya, to share what Grace is talking about in the course. Over to you, Grace.
Sorry, thank you so much. And it's a pleasure to meet you all. Grace Mutungu, I'm currently working with Open Society Foundations and managing a digital ID program that's in the making. But besides that, I'm also a technology researcher in Kenya and Africa more generally, where there has been a really great move towards digitalization of everything, where especially from a development perspective, there's this idea of leapfrogging, which is skipping other things you need to learn and just getting straight to the technology because there's an assumption that others have learned for us. And in the course, I talk about the risk of approaching technology in this way where everything, for every problem, technology is seen as a solution. And the risk comes from the sense that the society you're bringing technology into was not a blank society. It already had its own dynamics and even existing structural problems. And one example that I really like to give, which is quite simple, is when judiciary, for example, in a lot of African countries, because of COVID, there was the move towards e-judiciary, where people were supposed to open accounts online and access the justice system online. And so one thing that was decided in Kenya was that you needed your national ID in order to create an account. You needed to know the national ID number of the person you wanted to sue in order to create a suit in the system, which ignores all the complexities surrounding national ID in Kenya. There are a lot of communities who face barriers to accessing that in the first place. And so there would be no way that they would be able to access that service. In fact, around that time, there was an ongoing case contesting digitalization of that national ID. So you can imagine how that becomes a substantive and even procedural barrier, because you completely lock out people from accessing the system. And then, of course, there are so many other problems that come in with accessing the system, because there are all these underlying assumptions that there is power, that people have digital literacy and all the skills they need in order to access such a system, and so on and so forth. Yet in reality, you find that even the judiciary itself, even the advocates themselves, who are the professionals in the system, actually needed some awareness and education into the digital world. And so my call is that we should not make assumptions about the society which is being taken into digitalization, and that there is need to avoid what is now being referred to as solutionism, assuming that technology is a solution to every problem we come across. Thank you.
Thank you, Grace, for that cautionary tale and for sharing some of the examples. We would also request the participants, while we are priming up for more questions, to please feel free to raise your hand. I saw that someone had raised the hand and put it down. We will definitely come back to you soon, but also take questions from the chat. I would now invite President Aldana to briefly introduce his part of the course, and then move finally to Isabella. President Aldana, over to you.
Great, thank you, Patrick. I provided an introduction to Module 2, which is AI adoption across justice systems. In that course, we considered the benefits and risk of AI adoption into the justice systems. The course also had an objective to provide some examples of AI adoption for civil and criminal proceedings, as well as consider the different rates of AI adoption in different contexts, and also the pros and cons of risk assessment strategies when procuring AI solutions, as to maximize the benefits and mitigation risk. That's what the course covered. And I provided the instruction. There were other lectures in that course as well.
Thank you, President Aldana. Isabella, over to you. You cover a particularly topical issue which I've been looking at the chat, which is on online courts. And there is a lot of discussion around digitalization, a lot of discussion around response to COVID and how things went digital. But perhaps you can briefly tell us about what is the difference between online courts and using video conferencing facilities to make proceedings online. If you can add some of that nuance, that would be great. Over to you, Isabella.
Of course, Pratik. Thank you so much. So I'm responsible for the module on online courts. In my lecture specifically, I address the way technology is reframing the way we deliver justice. And we start addressing the difference between courts that simply operate online and online courts. So when we talk about courts that operate online, we're just taking the same steps that we take in the physical world in the virtual one. When we talk about online courts, we're talking about using technology to reframe the way we deliver justice. So we are rethinking the way we do things from this new spot, from the new possibilities that technology brings to us. And when we talk about online courts, we have two basic pillars of this movement, of the movement that gained this name. The first one is online dispute resolution systems. We have new systems that bring new ways to deliver justice. They are pretty much based on private initiatives, such as eBay, for example. And we address the new possibilities that online dispute resolution systems bring. For example, what might happen if in the beginning of the lawsuit, we deliver information to the parties so that they understand exactly the position in which they are, their chances on that lawsuit? Would this increase the chances of a settlement or not? So this is the first pillar. There is much that might be done regarding online dispute resolution systems. And we have one specific class on the best experience on this, that is the Civil Resolution Tribunal of Canada. And the second pillar of online courts is the use of AI tools to assist judges. So how can AI be used to help us? And we talk about several different experiences. Brazil is a very good example on this. In Brazil, we have more than 41 projects of AI in the judiciary that start with very simple things like an AI system that help you identify that a lawsuit has been brought again to the knowledge of the judiciary in a way that it shouldn't have. And we can have other kinds of experiences that bring more opportunities, but also that are more dangerous. For example, we can use an AI tool to draft decisions for judges. So when we talk about these two pillars of online courts, we talk about the opportunities that they bring, but we also talk about their downsides. So when we talk about ODR, we talk about the issues regarding cybersecurity. And in Brazil, we had a lot of problems already in this field. And we also talk about digital divide and how could we face digital divide when we take courts to this new space. And when we talk about AI tools in the judiciary, we must address very important situations regarding the opacity of algorithms that adopt machine learning and also the huge problem of discrimination. And our understanding is that if we think about these problems, the chances increase that we can use technology to really increase the rule of law values.
Thank you, Isabella, for that introduction. So what we will do now is, I do have certain planned questions, but I think it would be useful to jump into the questions from the participants. And I see that we have one participant who's raised their hand, but I'll begin first with the question in the chat here, which is from so Ricardo Bernal, I think you can go ahead with your question. I was going to read your question. Over to you, Ricardo. Ricardo, can you?
I can see his question here, Pratik. I think it's it might be for me. If you want, I can just reframe his question and answer if he doesn't want to speak.
I
can see that he's trying to mute and unmute himself, but it seems to be not working.
Perhaps we can wait a bit while if there's a technical issue and then come back to the question. But I also see the hand raised from Ruya. Ruya, the floor is yours. Please go ahead.
Hi, can everybody hear me?
Yes.
Perfect. So thank you so much for this course. I learned a lot. I'm almost done with it. I am a doctoral researcher in the field of law and AI, and I'm currently looking at transparency in a holistic way. And so I was very pleased about your approach to transparency, and it is most definitely very important to talk about the explainability in decision making and how that affects the judges' decisions and the court procedures and things like that. But on another approach to transparency, I wanted to talk about another challenge we face, which is the institutional challenges, the already available information to the judges or any part of the actually judicial system is not being processed properly because they lack the capacity to understand the already available technical information. So in that sense, it's not necessarily the only answer to raise the technical explainability of a decision making if it's not gonna register to anyone, if that information is not gonna register to the court system. So I wanted to just ask, what can we do to combat transparency in an institutional sense, not just raising the explainability in decision making, but us as legal actors, what can we do to combat these institutional challenges?
I see that Isabella has raised her hand, but I also think that Nicola may want to come on this at some point as well. I see him nodding. Yes. So Isabella, over to you.
Okay, so I'm starting with some of the things that we're doing here in Brazil. First of all, we need continued judicial education on this, and we need that judges do not need to be programmers, but they need to understand how things are done with technology. And specifically, my concern is on machine learning regarding the AI tools that help us. So judges need to understand the basics on this. How does this happen? What are the flaws? Where do we need to pay attention? This is one thing. The second thing is that the legal system needs to reframe itself to convey information that not only judges, but also the society, bar associations, etc., might understand regarding these initiatives. In Brazil, we have something that is really interesting. There is a public panel that is available online, that is organized by the National Council of Justice, that has information on all the 41 projects on AI that we have. This panel brings information such as who has developed, where does the data come from, what is the technology adopted, is the technical team able to explain how the input became the output? Does the non-technical team, is the non-technical team able to explain how the input became the output? Has the algorithm been analyzed regarding bias, etc.? So there are a lot of informations that are available to anyone. This is very important. This information regarding the characteristics of these initiatives. More than that, I think we need procedures. We need procedures regarding the development of these tools, especially if they are adopted in the judiciary. So we need to have some sort of public hearings. We need to have information. We need to convey information regarding how we develop these tools. And more than that, when we look at the scenario of regulation of AI in the world and the latest reports that have been publicized, etc., we see that one of the techniques that we might adopt to regulate these initiatives of AI in the public sector is starting by establishing a risk matrix that can distinguish the initiatives between the ones that have a low risk, a medium risk, and a high risk, so that we can develop a regulation that targets its risks, and so that we can understand where our attention needs to be focused. So I would say that these situations are measures that go beyond the technical take, because regarding the technical take, things are also being developed. There is a field in programming that is called explainable AI that's gaining traction in the last 2 years. But as you mentioned, it's very important that we think about institutional safeguards. And these ones that I brought are, in my opinion, some initiatives that should be adopted all over the world, because they are good practices. I see them as good practices.
Thank you, Isabella. So I see it's at a technical level that we can have initiatives for transparency, and then more at an institutional / organizational level. And you mentioned some of the upcoming or draft AI Act and the risk classification, but there are several others. But now I go to Nicola to share some more insights on this. Over to you, Nicola.
Thanks. Well, I think that the governance of AI is following two main routes to simplify. One is the regulatory route, like the EU Act in the EU, where it's about voting a law and entrusting the competence of our enforcement to an independent organization, an independent agency, a data protection agency, empowered with more capacities and more responsibilities to directly deal with the market, or the adjudicatory route, basically entrusting the court system, judges, with the possibility of not only dealing with the uncertainties and whatever is left for interpretation, but with more competences. And I think that there's a, in a way, a dirty little secret at the core of why typically an increasing number of regulatory systems go the regulatory route and not the adjudicatory route. It's a problem of capacity and competence, because we cannot see the AI revolution without seeing the big divide in terms of digital capacity that exists. AI does not fall from the sky, and incorporating AI safely and in a way that upholds fundamental values within court systems demand a huge effort in digital transformation and digital capacity building that sits at the forefront of the other digital capacity building. And let me give you an example. And it's not only a question of course, it exists more in the global south than exists in the global north, but it also affects, so-called developed countries. Let me give you an example. A country like France, for example, decided over 4 years ago to delay the deployment in its core system of machine learning based algorithmic systems to support decision-making with judges. Why? Because it was decided that the capacity of most French courts was so limited in terms of digital that it would be so-called risky and dangerous to build more, I would say, power within and delegate more powers within algorithmic systems if judges and the court system in general was not going to be sufficiently able to deal with that in a safe way. Was it right? Was it wrong? I don't want to be judging about it. I'm just saying that for AI to be deployed safely across court systems, there has to be a huge digital capacity building effort, and we are not yet there. Most of the time when we talk about digital governance, we talk about empowering the executive branch or the legislative branch, but the judiciary is systematically left out of this effort. We need more money. When we talk about justice reform, we need to talk about how do we build more digital capacity. Only when we do that, we can move more safely towards incorporating algorithmic AI systems. Yes, in the global south, there are opportunities for greenfield and brownfield leapfrogging. And because of necessity, we may have to accelerate the deployment of a few algorithmic systems, but this comes with risk and opportunities. And that's why bridging the global divide and engineering cooperation between the South and the North is so important, because at the end of the day, we have similar challenge as it regards the safe and human rights aligned adoption, responsible adoption of AI across all judicial systems. And we have to come together, as we're trying to do with this MOOC, to identify challenges and identify and engineer new solutions, which indeed belong to institutional development at large. Thank you.
Thank you, Nicola. I also see that there's a question for you in the chat, so if you can also respond to that from Malud. I just wanted to also add that the lens that you took around regulatory and adjudicational capabilities, I think digital governance and capacity building, even at the regulatory level, it's a huge need to strengthen capacities of regulators, because if we have the complicated laws that we are getting now with all these kind of risk assessment, it requires a lot of state capacity to implement them as well. We've seen in antitrust regulation that already huge amount of issues coming across in terms of implementing. But I see that we have, I don't know, we have a question from Anna, but before we had Ricardo, but perhaps we move to Anna and then we move to Mariota. Anna, over to you.
Hola, yo soy jueza.
Hello,
Hello, I am a judge. I am for Ecuador. I am starting the second stage. I've been a judge for the past 19 years. I would like to know how judges have reacted towards the challenges of explaining their decisions when they have used AI tools. So how do they argument? How do they explain their decisions? Which is what I understand the judges are now doing. Something that I am also interested in is how they assess the proof or the evidence, because this is an essential element for decision making for every judge. So I would like to know, I mean, I know that there are many projects, I know that there is a lot of experience, but I would like to know what other judges are doing when they are faced with these challenges.
Thank you, Anna, for that question.
Were you able to hear me okay?
Yes, very well. So I don't know if we have one of the speakers who would like to take it up. Please feel, yeah. Go ahead, Isabella. Yeah, Isabella, and then perhaps Benes, if you would like to take it up as well.
Yeah, I don't know if Benes or Nico can answer the second one, because we don't have like this kind of initiative to value the in Brazil. So how do judges argue when they use AI? What we have in Brazil are still initiatives that support judges, but they do not decide in their name. So for example, you can have an AI tool that will give you that will highlight a precedent, that will highlight a law that you could adopt. There are some initiatives that might even draft a decision for you, but it's your responsibility as a judge to check if everything fits with the situation. You can have an AI tool that would select among the models that you have developed on your bench, the one that seems to fit better with that specific situation. So in these situations, judges keep doing their jobs as they would before. It is very similar to, actually in these situations, AI acts like a human assistant, the same way as human assistants would act. Things start to get more difficult when opacity comes in and the system does not help you do what you usually do, but recommend a course of action. So, for example, if you need to do risk assessment, then you have a problem because you have an output. This person is a dangerous person. There is a risk that this person would do that again. And you as a judge, you don't know how did the algorithm got to that decision specifically. And in this situation, much more than how the judge that's ruling the case should act, it's important to see how that algorithm was developed. So the way we control the situation is, in my view, is much more how was that developed and a procedure to developing that, testing that, controlling that, etc. then afterwards. So one of our concerns in the classes is to highlight that in some situations, when the algorithm takes a part of judicial reasoning, then we should focus our concerns and we should focus our work in the previous moment. We shouldn't let this to the judge. I see problems that happen in this kind of situation, not as a responsibility of that specific judge, but as a responsibility of the judicial system that has decided to adopt that algorithm in that situation. At least that's how I see things.
Thank you, Isabella. Benes, would you like to take this? I'm sure there is this kind of conversation and experience also coming from your trainings in the US.
Sure, thank you, Pratik. I didn't turn on my interpretation quickly, but I think I get the gist of the question. In the United States, the use of AI in decision making is still pretty limited. In our module, we talked about the use in risk assessment and pre-sentencing in a limited way. And so, judges play a key role, I think, in ensuring that the fundamental concepts of fairness, due process, obviously truth, that's their kind of prerogative. And so those are the things that judges need to keep in mind when using AI or use of algorithm in their decision-making process. So again, in the United States, still pretty limited and narrow in scope in terms of use of AI in decision-making process.
Thank you for that. I think the second question was, how is AI developed for judicial users around the world? And does judicial system allow participation of all actors in programming of AI for judicial users? So is this in a multi-stakeholder collaborative manner? What can be the oversights when AI tools are developed for judicial systems? I don't know if any one of the panelists would like to take up that question, or it's a question for further reflection as well. Nicola, you would like to go ahead? Yeah, please.
Yeah, very briefly, in a provocative way, I will say that there is no legal industry, apart from large law firms, mostly in the US, where there is litigation-intensive market that creates room for capitalistic approaches. As a result, being undercapitalized, there is no market where we would have this normalized way of having standard-setting bodies, defining standards that would guide the responsible development and deployment of this AI for legal system. And that's a problem. That's a paradox, but that's a problem. And so my answer to you is that no. The way in which these products more often than not are developed looks like a jungle. And what we're trying to do at the Attention Roundtable with this MOOC is to help create on the long run the conditions to bring a little bit of order, a little bit of industrial common sense in the way in which these products are developed on the judicial market. That won't be easy. It will take time. It will require investment, but it's essential if we are to uphold democracy and the rule of law in the age of AI.
Thank you, Nicola. Just to add to this, I think when we talk about development of AI systems, certain principles have been developed. And at last count, I think between 2015 and 2020, about 117 of these AI principles were developed. And UNESCO actually developed the first global recommendation on the ethics of AI. So this lists out certain principles which can then usefully inform the development of AI tools. The challenge, though, remains on how to translate these high-level principles into mid-level norms and guidances in particular domains, and to also provide context, which is, I think, the work which is ongoing in a lot of places. I'll move now to Mariota, who has a question, and then to Ricardo. Over to you, Mariota.
No, thank you. Actually, it's not a question, it's a comment. I'd like to echo what Nicolas has said about the importance of building capacities around the judicial systems for development and use of AI, and echo what Isabella said as well in terms of the importance of having this process being a multi-stakeholder process that brings around the table a series of people, particularly the ones who are at most risk of suffering harms, or in the past have suffered harms. And I'd like to highlight one interesting paradox of the issues of harm in past decisions in built-in big data, and judicial systems. And I think perhaps it's one of the very few sectors in which this paradox comes through. Judicial legal frameworks are very much built also on jurisprudence. And jurisprudence is exactly the experience of judges as applied, to case loads that they have, analyzed. Therefore, when we look at what is actually built in terms of jurisprudence, it already may have, issues of bias built in. So when we talk about building legal frameworks out of judicial systems, particularly using big data, the importance of debiasing, and sometimes to actually, thinking, how do we build new jurisprudence for the digital age that is actually going well beyond what is considered the legal standard based on past cases that have actually, that we need to actually confront on a deeper knowledge of what we understand justice to actually be, in this process. So, it's just like, the other day we were talking about elements of using big data to mitigate climate change. Well, climate change was, big data was actually built on systems that are of using fossil fuels. So if you actually use those big data to build, decisions for climate change, we end up actually baking in some of this. Same thing happens in legal systems. And therefore, there must be some mechanism to innovate, in the jurisprudence area. And, maybe Isabella could comment on that, or others from other legal systems around the world would like to comment on those issues as well. Thank you.
Thank you, Mariota. I think now we have a very interesting conversation framing around, one, how can judges, for instance, with Anna's question around explainable AI, and how can judges explain decisions which have been made based on the use of AI and so on. And I think Ricardo takes that question further. So I'll open the floor to Ricardo. Over to you, Ricardo.
Hi to everyone. Can you hear me?
Yes, very well.
Okay, my name is Ricardo Bernal. I work as a senior officer of Municipal Civil Court in Barranquilla, Colombia. And I have a question. Will judge end up being displaced by machines? On the other hand, will it be necessary for a judge to have knowledge about algorithms and technicals and programmatic operations of AI, or should they submit to professionals who knows these issues but know the law? Thanks.
Thank you, Ricardo. Three very important questions. I see Isabella has already raised her hand. Over to you, Isabella. And perhaps after that, Grace, if you would like to share your thoughts as well. Over to you, Isabella.
It's a very interesting question, and something that people always ask. So, will judges be replaced by machines? Will lawyers be replaced by machines? Will everyone be replaced by machines? And the answer is no. It can never happen in a field that is changing. What we need to understand is that algorithms, they are trained on data, and data always regards the past, what happened already. So an algorithm, at least in the state that AI is now, cannot bring new answers to problems. And we live in a constantly changing world that is always bringing like new problems. So what we can do is use algorithms to answer the problems that we already identified, and they are given answers based on the past. And we need to have the human judge to face and to give answers to new problems that arise. Or we need this human judge also to look at the problems and say, this is not the same as the other ones. So to make the distinguishing, to make the overruling, we'll always need a human judge. What we can do with AI is taking that situations that are repetitive, that are massive, that are taking a lot of our time without need, because you don't need like a human reasoning to solve that, and give the situations to be addressed by algorithms, of course, supervising this. And then you release these judges to use their time to situations that really demand like human reasoning, to complex situations, to new situations. So when people do this kind of questions, will any profession end up because we're going to use algorithms? The answer it's usually no. The human machine is always the best equation, much more than the human itself or the machine itself. So there's still room to judges, and there will still be room to lawyers.
Thank you, Isabella. It's a constant concern across sectors of whether AI is going to replace us. I think the course also talks about, Ricardo, the aspect of narrow artificial intelligence and general AI, and I think it's President Aldana's module where this topic is covered. Yes, President Aldana, I see you wanted to speak. Yeah.
Well, I was going to say I agree with Isabella. The use of AI really should be in a narrow areas where efficiency is important. Where, for instance, in Brazil, obviously the addressing some of the large dockets and how to manage that system. But you can't replace humans as judges. There's an element of compassion and mercy in that. I don't know if we could ever teach a machine how to do that. Obviously not, and hopefully not. But what this endeavor by UNESCO and what the Future Society IEEE have endeavored in AI and a rule of law in the roundtable is really for us to create the future path of AI. That, as Nicola said, AI doesn't fall out of the sky. It's not magic. It's not predetermined. It is beyond. It is within our influence, and so the judiciary plays a key role in shaping that path and the kind of engagement with different stakeholders. It's the opportunity for us to make sure we have control of it. And judges at the end, I mean, humans in the role as judges is central to making sure that the concerns that have already been raised are addressed. And it's in this kind of stakeholders engagement that we hopefully will shape a future where AI plays a role in a way that protects the values that we've already discussed.
Thank you so much for that. Grace, over to you.
I do agree to an extent, and I think what the president and Isabella described is the ideal, that we would always want to have space for human intervention. But I also think that the reality is that there's also a lot of experimental technologies happening everywhere. And it's worse where there's no transparency or space for a myriad of stakeholders, civil society, researchers, to expose these experimental technologies and also to resist. And so while we may always want to have human intervention, and in fact, a lot of the regulations that are coming out, including even in the global south, try to protect people from automated decision making. In reality, we know there are so many examples of experimental technologies, and at times it may not necessarily be in the judiciary. You find that especially in spaces that are protected, like national security operations, border control, and all that, there's a lot of experimentation going on. And still to Ricardo's question on, therefore, if these are the challenges we are facing, does it mean that judges should focus on the law, or should they focus on technology? I think at this moment, which we're in, which is kind of a transition, we can do what we can to keep increasing the capacity of everybody in the legal, in the justice system, from judges to lawyers to court users and the public at large. But I think in future, and what I would hope that this course becomes, that in future, judges would be trained from the word go, even when they're taking their legal education, that they would have such a good understanding of all these issues we are speaking about, such that if these issues came on onto their docket, whether it's to borrow Nicolas's analogy, whether it's on the law of AI or AI of the law, that this would already be issues that they're very well versed in. And perhaps at the moment, and I don't know whether this has happened anywhere, perhaps at the moment, maybe what we need to also think about is specialized courts that deal with matters technology, the same way that issues like environmental justice have specialized courts, labor laws dealt with at specialized courts, and so on.
Thank you, Grace, for that. I think at this point, I would also like to shift gears a little bit to what I see that Mariota has raised her hand. Mariota, do you want to respond to Grace's point, or it's a new point?
No, it's just a compliment to her point, because I think that she very well put, the very reasonable and important point. I just want to say that perhaps we need to look at the different types of why certain laws exist, and where AI could really help. So at certain moments, you're actually looking at, for example, the courts addressing issues of market failure. For example, the disputes between about certain property rights or things like that. Others, it's about, are we going to really be supporting crossing certain lines in social policies and so on and so forth? So it's the issues of discrimination, the issues of, and others are really issues of that are unmitigatable if you have a failure in a decision by AI. The issues of, for example, recovering from, if you decide on imprisoning somebody or taking, that kind of extreme measure, there's very little that you can do to actually recover. You can, redress some of that, but the harm is already done. So it's not it's an issue of where can AI really be considered an assistant, in a way, and where it can actually, be part of a support system only, that that judges can actually rely, draw upon, so in the EU, you actually look at a high risk, versus low risk AI systems. And in the legal system, I think, frameworks like that would be extremely helpful to look at, in terms of the types of issues that are being addressed, because there are quite a few, there's a tremendous backlog in very, sometimes in these very small areas that could be mitigated by, a more persistent use of certain types of AI.
Thank you. Thank you so much, Mariota, for that insight. Nicola, I come back to you, but I understand that Professor Lawal Mohammed Anka has been raising his hand, but physically, so I didn't notice. Professor Lawal, if you would like to take the floor. You are on mute. We don't hear you, but I understood that you are on mute. Professor Lawal, I see that you're speaking, but you are on mute. If at the bottom left corner there's the mute button.
Miguel, ¿cómo te fue?
Okay.
Perfect. Now we hear you. Over
okay? Okay. I would like to welcome all the distinguished personalities in this important gathering. I have some few questions that I want to ask to a particular guest speaker during the training program. Everyone knows that training and retraining of judicial staff is extremely important, and it makes the system works extremely well. So I don't know if lack of training and retraining
is not given to judicial staff, what will be the consequences? I want to throw this question to Grace in the forum. Hello. How do we address that problem? Lack of training for judicial operators that gravely undermine access to justice. So how do we address this problem?
Thank you, Professor Laval, for this question.
Yeah.
And I think
this question goes directly to Grace Mutungu, particularly in Africa, with special focus to Africa.
Thank you, Professor Laval. So Grace, over to you, and perhaps then we can also hear from the experience of National Judicial College to facilitate what is happening across different systems. Okay. Over to you, Grace.
I mean, I think I just noted when the president spoke about the National Judicial College and what it does. And I was also thinking about it in terms of what is also there in some of the African countries. And I think that aspect of having a training arm the role of that cannot be understated. And now speaking to UNESCO, the Future Society, and any other organization that may be involved in issues of capacity building for the legal sector. This is a gap. I agree with Professor that this is a gap, and especially in Africa, where on top of that layer of just the normal gap in new and emerging issues, there's also so many other gaps, starting from procurement and how these technologies are coming in, and so I'd also like to throw it there to UNESCO and the other organizations that perhaps this is also an area that needs to be looked at as we address the bigger issue of ethics of AI.
Thank you, Grace. President Aldana, over to you.
Yeah, as the speakers earlier, in particular Judge Ferrari had mentioned, judicial education is key. And obviously part of that is the commitment of governments to provide the resources, right, to have the training available. In my prior life, I was the chief legal engagement for U.S. Africa Command. And so we did a lot of training, advancing rule of law and all over Africa. And the key piece that I've discovered there is that you have to raise the issue, and as Grace pointed out, this is a gap to those people that can provide the resources. Obviously, your government needs to be involved in it, but there are other civil societies that are providing training opportunities around Africa. So the issue of education of AI needs to be raised for resources and funding. So in UNESCO, obviously, the reason that this MOOC was created is to provide training opportunities globally. The National Judicial College is very committed in this arena of educating judges, not only in the United States, but all over the world. And so that's why our course, week-long course that was postponed 2 years ago, we're committed to doing that next year. And we're continuing to do other webinars. Our webinars are normally available for free to anyone around the world. So everyone's welcome to participate in that. But I think the key is to keep raising that this is an important issue, worth funding, worth providing opportunities from governments, but also there's so many other civil society organizations that are working throughout. And for my work in U.S. Africa Command, I know that's a military command that's trying to build capacity among the security sector, but there's always an educational component there. So, and particularly with judges. And so you need to raise that issue, and hopefully there's some funding opportunity capacity to be developed there. So.
Thank you, President Aldana. Just also to respond from UNESCO side, and then I give you the floor, Professor Laval. At UNESCO, we've been working on the Judges Initiative since 2014, which has trained judicial operators on questions related to freedom of expression, access to information, safety of journalists in over 150 countries. And this work is not only online, it also involves regional trainings where we have a train the trainer modality. So we organize regional trainings where we bring in national judicial colleges to be able to strengthen capacities in a more sustainable and long-term way. And the intention now actually with the course on AI and the rule of law is exactly the same. We have this global MOOC where we are reaching in this first iteration about 4,000 judicial operators in 7 languages. But the idea is now to create a toolkit which can be used to sustainably inform national judicial academies to be able to train judges, lawyers, and so on at the national level. So that's going to be UNESCO's response, of course, with all our partners around the table. I wanted to give you the floor, Professor Laval, before I move to Nicola, if you had a question or a response. I saw that you had raised your hand. Perhaps we move to Nicola then, and then see if Professor Laval is back. And I have 3 questions in chat, and then I'll bring those questions in. Over to you, Nicola.
Well, thanks. Number one, I may answer to one question, Ricardo's question on the chat. I think it's important whether AI has been used in the context of economic jurisprudence, particularly as it applies to telecom. I'm not aware of, I'm aware that, well, in the context of some, I think, litigations over the attributions of a few licenses, like 4G licenses or 3G licenses, there might have been electronic discovery used in the context of litigation between 2 parties. That's one. And then depending on what you mean by AI, in the way in which some of the telecommunication licenses and the economic model underpinning the valuation of the licenses have been developed, you could estimate that some of the simulations, advanced simulations of the value potential of these licenses could amount to deploying AI, advanced modeling, in the way in which they have been valued. So that's maybe to answer your question. So it's diffuse. One has to see AI also as a diffuse set of technologies. And that leads to my point. I wanted to build upon what Marielza has been saying and to a key point that Grace mentioned. When we designed that course, and we looked at the impact that we would like to create and what empowerment would mean in practice, we thought about the following set of things. We knew it was going to be judicial education, but more on the education side, understanding the what and the why, more than on the training side, understanding the how. But we yet wanted to empower judicial operators with, key outcomes. And one of the outcomes is the following. We hope that as an outcome of this course, judges and legal practitioners understand much better why it is crucial to build a wall of dignity between decision supporting systems, aid to decision systems, and automatic decision-making systems. It's very important that we create the conditions for judges not to fall into the trap of misunderstanding that supported decision systems can be rubber-stamped into an automatic decision-making systems. When you understand the limitations of correlative technologies, you understand the limitations of black box algorithms, especially on critical decisions on detain or release, you have to consider that you have a responsibility to absolutely not consider this system as an automatic decision-making system, but you have to unleash your entire intelligence, power, and the institution has to give you the time on the docket to do that so that you can decide in conscience with your full, I would say, ethics in place therefore using the system only as a supported decision-making systems and never. So the slippery slope between a supported decision-making systems to an automatic decision-making system is extremely dangerous. And we hope that equipped with this course, you can help build, as practitioners, you can build the wall and never let a supported decision-making system become de facto an ADM.
Thank you, Nicola, for that, and also taking on the question in the chat. We have one more question, which is, when we are judging on family cases, facts change in every single case. Is it useful, the AI, when we are facing, is it useful to use AI when we are facing family trials in court? And I saw that also Judge Alfonso has also responded. So first we go to Judge Ferrari, and then perhaps if Judge Alfonso, who's also responded in chat, wants to share experience from Spain as well. Over to you, Judge Ferrari. Thank you.
Thank you. So what I would say generally is that if facts change in every single case, the answer is no, we shouldn't use AI because we don't have like consistency to adopt this resource. But at the same time, we can use ODR, we can use online dispute resolution systems in the family field, and you can have good results with that. There is an initiative from Netherlands that's called Digitalizing that a little later became Justice for Two. It's its current name. It's not a public ODR system, it's a private ODR system, but the judiciary of Netherlands support the use of the system in familiar cases. And what this ODR tool does is to structure the communication between the ex-couple in a way that there are some questions that are made, and the communication between them is structured in a positive way, so that you don't let the conflict arise or increase. So even when you cannot use AI to decide because you don't have consistency, because you need an individual take on every case, there might be some resources or some technological resources that you can adopt. And this kind of tool that structures communication in a positive way is something that you could use in this field, in this family field.
Thank you so much, Judge Ferrari, for that answer. I'm also watching the time. In the chat, we will also share a link for feedback on this session, because we want to learn also from what is working, what is not working, because we are going to do several of these. So really taking an iterative approach. So please feel free to share your feedback there. We have a question from Anna. Anna, please go ahead.
Hola, sí, solamente quería...
Yes, let me just say, to build on to the AI question in family law, there are some cases that are very much repeated. For example, child support. When we need to define child support amounts, this will be a calculation between the parent's income, the parent who is responsible for paying child support, and the beneficiary, child or teenager. So I think that in cases as such, AI could be useful, right? Why? I mean, I'm not black box or opaque algorithm, because in that case, it is not possible to show transparency in the decision tree and in how we are making that decision. But now, in cases such as these, for child support decisions, I think it could be useful to use AI only in certain cases, like this, to decide on this child support amount, or when we need to make a very quick decision, when we are speaking about protection measures, for example, something that could be very difficult to do in a very short turnaround time. If we need it overnight, for example, which sometimes it is very difficult to decide when it comes to minors. And that's it on my end. Thank you.
Thank you so much, Anna, for that clarification, that comment, and thank you so much to our translator also. So I see Professor Laval, you're back and you've raised your hand, and then we move to Arturo. Over to you, Professor Laval. Yeah.
Yeah. Thank you very much. My second question actually still goes back to Justice Grace Mutungu. What is the progress regarding artificial intelligence interaction with access to justice in the African context? Because this has become almost a controversial issue. I want Grace Mutunga to comment on this important issue.
Thank you, Professor Laval. Grace, would you like to go? Would you like to take it up?
I'd say that everything is segmented, that different countries have different initiatives regarding AI in general, and then now AI's application in the justice sector. But I do know for sure that as far as COVID-19 responses, there was a lot of AI application. One thing I know that I think is very interesting and exciting is that the African Union is looking at AI and its application to human and people's rights. And it will be, they're going to do some research or have already started doing some research. I think that is really exciting because it will generally, I don't think a lot of people have looked at AI and its effects on collective human rights. So that is something I'm looking forward to, and I think it's also something to note and contribute to, even from this, from the discussions we're having today, the intersection of AI and access to justice.
Access to justice.
Access to justice, yeah. So as far as I know, I think all the processes are very segmented, and I hope using that momentum from the process in the African Union, I hope that we shall slowly come towards a collective idea on when to use AI, when not to use it, how to protect human and people's rights, and so on and so forth.
Thank you so much, Grace. And I see that the chat is really lively, but I will try to pick up a few questions, and then I would really request some of you who've put in some of these ideas also, Grace, what you mentioned about AI and collective human rights in the survey form that we've shared, because you're also collecting new ideas of what we can take up later. So before we go to Arturo, I just want to put out some of the questions. So there's a question from the judicial system needs not only to work justly and respect human rights, but also to be trustees by society. So it is considered legitimate to solve conflicts. With such a novel tool as AI, how can the confidence be gained and maintained? I think it might be more difficult in some cultures than others. For example, the title of this MOOC in Spanish translates as Defending the Rule of AI in the AI Era, which implies some hostility towards technology. We had a lot of discussion around what would be the appropriate translation. So just to put that question out for our panelists, then there's another question around what level of technical knowledge do judges need to have on AI to better benefit from AI-supported judgment. I think that's a task which we shall really direct NJC to put its Judicial College hat on and guide us through. And so I put these two questions, and then I'll move to Arturo, and then I would request the panelists to respond to them together. Over to you, Arturo.
Buenos días, ¿se me escucha?
Good morning, can you hear me?
Yes, we can hear you.
Muchas gracias desde Bolivia.
Thank you so much. Greetings from Bolivia. Hello to everyone who is here in the panel. And I want to thank the organization, and I want to thank our professors in this such lovely group. I am a judge in Bolivia, in the city of Potosí. And in our day-to-day life, or the reality in Bolivia is that AI has caused problems, and really the COVID-19 pandemic has really turned access to justice. It has made access to justice more difficult. Also considering the digital gap and the very significant digital gap that we have in Bolivia and the many problems to access even the internet, this has brought along many technical difficulties. So many cases we have had to resort to, for example, online hearings, but those online hearings really pose great challenges to access these tools. So in terms of civil law, how can we use AI? Or I would like to know what has happened in other countries. In Bolivia, really hearings have turned into virtual hearings mainly. And the use of algorithm or black box algorithms is very much limited considering our own reality, based on the capacities of the judge or the capacities of the person that needs to use this tool. Because when it comes to making decisions, or when it comes to solving particularly complicated cases, judges are supposed to really take into account the nuisance. And I believe that these digital tools could be very limited when it comes to handling these human nuances or the small details. So basically, I want to know what the experience in the use of AI is when it comes to civil cases. And I would also like to know if there's, for example, the possibility to draw, maybe in the framework of this course, certain good practices or a protocol maybe for the use of AI in our activities. And then we could use this as a baseline to adapt these best practices to our own country and our own national context.
Thank you so much for that question. I think you touch on quite a few points that we've been hearing. For instance, what are these standards? What are these good practices emerging around the world? And we would definitely like to bring that to the discussion. Unfortunately for today, though, we are out of time. And I would really request, give our panelists the last word. If you want to address some of the questions that you've heard, combine it with your closing statement with 30 seconds each, and perhaps we can start with President Aldana, then move to Judge Ferrari, then move to Grace Mutungu, and then perhaps to Nicola. So over to you, Judge President Aldana.
Great. I guess I want to say, as the AI enters the courthouse door, the questions that we should ask is when AI is used appropriately, AI can increase the efficiency of our processes and raise the quality, accuracy, and consistency of our decisions. But when used inappropriately, AI can undermine our need to know, explain, and ensure fairness, and potentially perpetuating biases under the guises of objectivity. So as we've learned, AI really is a double-edged sword. It can help us, it also can harm us. And so we need to make sure that we're consistently engaged in understanding the use of AI, particularly in the judiciary, which plays an important role in all of our lives. Thank you.
Thank you, President Aldana. Judge Ferrari, over to you.
I agree 100% with President Aldana. I think it's not what we do, it's how we do what we do. And I'm really happy that this course has raised so much awareness on the topic. So I think we're in the right path.
Thank you, Judge Ferrari. Grace, over to you.
I'd just like to use the opportunity to thank you so much for the opportunity to learn about different experiences with AI, and I've taken a lot of notes, and I'm really grateful for that. So it's a nice exchange where we learn from each other.
Thank you, Grace. Nicola.
I want to quote in closing my good friend Amandip Gill. We have to preoccupy ourselves as much with the misuse of AI as we have to preoccupy ourselves with the misuse of AI. And capacity building lies at the center of bridging the gap between misuse and misuse. And I think that what we have seen today embodies exactly what we hoped we would accomplish when we started this, the kind of dialogue, the quality of the questions. You see the limitations of the answers because a lot has to be accomplished. So I want to congratulate you, Pratik, Vanessa, Marcel, and the rest of the team, because this is exactly the kind of dialogue that we need to make progress on the responsible adoption of AI in legal systems.
Thank you, Nicola, for that. We move to Mariota for a quick remark, and then perhaps Alexandra, if you want to have the last word as well.
Thank you, Pratik. Thank you, everyone. I think that this is an incredibly important discussion because, particularly these issues of where are the limits and where AI can really help. The fact that we have backlogs, of legal cases in justice sectors all around the world, and big backlogs, means that justice is not being administered. And if there is a way of increasing efficiency, increasing effectiveness of legal systems, this is a quick, an important gain. So, of course, the consequences perhaps in product liability are different in consequences of a murder trial. So we need to really think, where are the limits and where we can really rely and deploy the systems in a way that really ensures that the justice is served. So I really like the way that Nicholas put it, the issues of missed justice as well as the issue of misjustice in the use of AI. So I think it's really fantastic, this discussion. Thank you all very much for these insights.
Thank you, Mariota. Alexandra, over to you.
Thank you very much, Patrick. It's amazing, very, very lively debate. And I couldn't leave the room without saying about the need of measurement, because many participants has raised so many concerns, worries, and challenge, and how to do in this situation, in that situation. Well, if we don't measure the adoption of AI by judicial actors, there is no visibility. And when we don't have visibility, there is no priority in the policy debate and in the debate in society. So we need data so that we can really understand what's going on in this intersection of AI and the judicial system. So there is a model on measurement that we will have the chance to discuss that. But I leave this message. Without data, there is no visibility. And without visibility, there's no priority. So let's think about how to measure the impacts of AI in the judicial system. Thank you so much, and congratulations, Patrick, Mariota, Vanessa, and all the team. This is an amazing achievement. I'm very happy with this. Thank you very much.
Thank you so much, Alexandra. And just to also inform all the participants that we have the second, I see Judge Professor Lawal, I'll come to you soon. We have the second talk and discussion planned for the 21st of April, where we will actually discuss measurement issues as well. So if there are questions, I saw some questions around predictive policing and whether it should be banned or not, and discussions like that. I think we will definitely engage, and we may have some answers and some we don't with the participants and the lecturers here, but it's already been great. Professor Lawal, 30 seconds if you have any final thoughts.
Yeah. I just want to ask about the use of AI improve administration of justice so far, because AI is still a new concept in many countries, and many countries are finding it very difficult to implement it. Perhaps maybe due to funding problem or due to the nature of the policies of a particular country. So has it improved so far? So far, has it improved the administration of justice, the use of AI?
Thank you, Professor Laval, for that question. And I'll take the liberty to quickly respond briefly to that point. I think it depends really on the tools, and there has been a significant development in analyzing previous cases, for instance, the entire case histories and so on. So there are specific AI tools which have been used, also using natural language processing, also for translation and so on. Okay. So there is some examples of that. Well, thank you so much to everyone for this wonderful conversation, and we look forward to engaging with you on the floor of the course. So please keep your questions coming, and also on the 21st. And from UNESCO side and from our partners, we are really happy to be here with you and look forward to engaging further with you. Thank you so much to NJC, to the Future Society, to CETIC, to IEEE, and also, without mentioning my team, Vanessa, Charlene, Jason, and Steve, who've been working really hard at UNESCO, along with colleagues from other organizations. Thank you to all of them. Thank you so much. Take care. Bye-bye.
Thank you. Bye-bye. Bye.
Goodbye. 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 Take care.